Professor Tom Reed, Director of the Widener Veterans Law Clinic here again. I get a number of questions from veterans and dependents that I think probably you might have similar questions, so I'm going to try to respond to them here. Just going to take a few this morning. For example, people have asked me, what is the VA claims process all about? You start every VA claim by filing a Form 526 with one of the regional offices in the United States. Every state has one regional office. Some states have more than one. The easiest way to get a Form 526 these days is go directly to the VA website, www.va.gov, and download either a form you can fill out online or a form that you can copy out, print, and then mail to your regional office. If you do an online form, the VA will automatically send that Form 526 to the regional office having supervision of the state in which you live. So for example, if you live in Illinois and you fill out a claim online, the VA will send that to the Chicago regional office, your regional office. And that's how all claims get started. First, you've got to file a Form 526. It's a 10-page form. The instruction book that goes with it is considerably longer. It contains many items of information that may not apply to you. You only have to fill out those that apply to your case. That begins the process. Once that claim arrives at one of the regional offices, it's developed. This is the VA's language for finding the necessary information to support your claim. The VA is responsible for getting all your military records and all your VA medical records if you've ever been a patient of a VA institution. If you disclose the fact that you have been to a private physician or physicians or hospital for your ailments, and you sign a consent to release form, the VA will get those records for you as well. Although I would strongly advise you to go directly to your private physicians and get the records from those people and turn them in yourself. Once all your records have been assembled, the VA does what we call adjudication. 3 rating specialists will read your file, and they generally come to an agreement as to whether or not your condition is what we call service-connected. Service connection means that something happened to you in service. You either got sick or got injured. You still have symptoms today, and there's a medical doctor's opinion linking today's problems with what happened to you in the service. And then they give you a % of disability rating. I suppose you are wondering what happens if you get turned down. We have rights of appeal, and you start that process by filing what's known as a notice of disagreement. That has to be in writing, it has to be dated, it has to refer to the rating decision by date that said we are turning you down, and you file that notice of disagreement with your VA regional office. It doesn't have to be sophisticated, doesn't have to be prepared on fancy stationery. As a matter of fact, if you write your notice of disagreement on toilet paper with lipstick, so long as it has the legal elements that I've outlined, it's legally effective. But you have to do that within 1 year of the date of your adverse rating decision, or you're forever barred from contesting that decision. Now you do that, you're going to get what's known as the decision review conference with a senior rater. That senior rater has long-time experience in VA cases, has the power to overrule the raters who gave you a negative decision. It's an informal process. You sit across the conference table and talk about your case. You may give some evidence under oath, but that's not required. If you don't win there, if the decision review officer doesn't reverse the 3 raters, then you must take what's known as a substantive appeal. The VA sends you a paper called Statement of the Case. This is a really important piece of paper. You have exactly 60 days from the date of that statement of the case stamped on the front to do your formal appeal on VA Form 9. If you don't do that, you're forever precluded from contesting the claim. Your VA Form 9 goes to the regional office that turned you down. That office in turn marks your case to go up to Washington for a Board of Veterans Appeals hearing. Now the Board of Veterans Appeals sits in Washington, but they ride circuit. The judges come from all over the United States, and they're each assigned to a decision team that covers anywhere from 8 to 12 states. Once a year or twice a year they come to your regional office for hearings in person. That's the slow track for getting a BVA hearing. The fast track is to travel to Washington, D.C. Those can be scheduled in a matter of a few months after your claim file has been delivered to the BVA. A system that's practically as fast involves what we call the video conference hearing. That can be done from your regional office. Your judge can be in Washington as if you had gone to Washington City for a hearing. And if you agree to that process, you can usually get a hearing within 3 to 6 months. Now, if the Veterans Law judge agrees with you and decides that your case was wrongfully decided, he or she will send it back to the regional office for a re-rate. If not, then you have another option. You may appeal to a court outside the VA system called the U.S. Court of Appeals for Veterans Claims. It's located in Washington, D.C. at 625 Indiana Avenue Northwest, Washington, D.C. 20004. If you want to take an appeal from an adverse BVA decision, you have exactly 120 days from the date of that decision to send a notice of appeal, again, formalities not required, to the Court of Appeals for Veterans Claims at the address I've given you. If you don't do that, you're forever barred from contesting that claim. I hope that gives you some idea of this process and how it works.